Tamil Nadu Judicial Academy. Appreciation of evidence in criminal cases. In a criminal case, appreciation of evidence is one of the first and foremost tests to consider the credibility and reliability of the prosecution version, both oral and documentary. The finding of the facts, the question of law, and conclusion of the judges of the court, culminating into judgment in a criminal case, mainly based on appreciation of evidence. Right from setting the law in motion in a criminal case by preferring an FIR, and after completion of investigation, filing the final report, ultimately resulting in producing and adducing the evidence before court, consist varied kinds of evidence, both oral and documentary, and the admissibility and reliability of such evidence should be considered by the court on the basis of facts and law for arriving at a just decision of a case. Therefore, appreciation of evidence is the heart and soul of dispensation of justice delivery system in criminal law. Criminal cases involves life and death problem of a citizen, and the destiny of the citizen is to be decided by carefully analyzing and scrutinizing the evidence adduced by the prosecution. The Honorable Apex Court in Rang Bahadur Singh vs. State of UP reported in EIR 2000 SC 1209 as held as follows. The time-tested rule is that acquittal of a guilty person should be preferred to conviction of an innocent person, unless the prosecution establishes the guilt of the accused beyond reasonable doubt. A conviction cannot be passed on the accused. A criminal court cannot afford to deprive liberty of the appellant's lifelong liberty without having at least a reasonable level of certainty that the appellants were the real culprits. In yet another decision, State of UP vs. Ramveer Singh, reported in 2007-6 Supreme Court 164, the Honorable Apex Court has held as follows. The golden thread which runs through the web of administration of justice in criminal cases is that if two views are possible on the evidence adduced in a case, one pointing to the guilt of the accused and other to his innocence, the view which is favorable to the accused should be adopted. The paramount consideration of the court is to ensure that miscarriage of justice is prevented. A miscarriage of justice which may arise from acquittal of the guilty is no less than from the conviction of an innocent. In a case where admissible evidence is ignored, a duty is cast upon the appellate court to reappreciate the evidence where the accused has been acquitted for the purpose of ascertaining as to whether any of the accused really committed any offence or not. The various aspects of evidence are as follows. 1. First information report. FIR is not an encyclopedia. It is only to set the law in motion. It need not elaborate, but should contain necessary allegations to constitute a cognizable offence. Evidentiary value heading. Section 154 CRPC. Uses of FIR. FIR not a substantial piece of evidence. It can only be used for corroborating or contradicting its maker. It cannot be used to corroborate or contradict other witnesses. This is as per Baldev Singh vs. State of Punjab 1990, 4 SCC 692 and State of Gujarat vs. Aniruddha Singh 1997, 6 SCC 514. Section 154 CRPC. FIR. Evidentiary value. Corroboration of its maker is permissible, but the first information report cannot be used as substantive evidence or corroborating a statement of a third party. This is as per State of MP vs. Surban, AIR 1996, SC 3345. Next heading, delay in FIR. Delay in FIR. The inordinate and unexplained delay in dispatching the first information report to magistrate. The offences in the account given by the prosecution witnesses and appearing from the first information report of the occurrence. The absence of any statement in the first information report as to the injuries received by some of the accused and non-examination of material witnesses. Conviction cannot be sustained. This is in the case Ishwar Singh vs. State of UP, AIR 1976, SC 2423. The Honorable Apex Court in the case of Maharaj Singh versus State of UP 1994 5 SCC 188 has held that FIR in a criminal case and particularly in a murder case is a vital and valuable piece of evidence for the purpose of appreciating the evidence led to the trial. The object of insisting upon a prompt lodging of FIR is to obtain the earliest information regarding the circumstances in which the crime was committed, including the names of actual culprits and the parts played by them, the weapons, if any, used, as also the names of the eyewitnesses, if any. Delay in lodging FIR often results in embellishment, which is a creature of an afterthought. On account of delay, FIR not only gets bereft of advantage of spontaneity, danger also creeps in of the introduction of a colored version or an exaggerated story. With a view to determine whether the FIR was lodged at the time it is alleged to have been recorded, the courts generally look for certain external checks. One of the checks is the receipt of a copy of the FIR, called a special report in a murder case, by the local magistrate. If this report is received by the magistrate late, it can give rise to an inference that the FIR was not lodged at the time it is alleged to have been recorded, unless, of course, the prosecution can offer a satisfactory explanation for the delay in dispatching or receipt of the copy of FIR by the local magistrate. The second external check, equally important, is the sending of the copy of FIR along with the dead body and its reference in the inquest report, even though the inquest report prepared under Section 174 CRPC is aimed at serving a statutory function to lend credence to the prosecution case. The details of FIR and the gist of statements recorded during inquest proceedings get reflected in the report. The absence of those details is indicative of the fact that the prosecution story was still in an embryo state and had not been given any shape, and that the FIR came to be recorded later on after due deliberations and consultation and was then ante-timed to give it the color of a promptly lodged FIR. The Honorable Apex Court in State of HP versus Gyanchand 2001 6 SCC 71 has held that delay in lodging the FIR cannot be used as a ritualistic formula for doubting the prosecution case and discarding the same solely on the ground of delay in lodging the FIR. Delay has the effect of putting the court on its guard to such if any explanation has been offered for the delay, and if offered, whether it is satisfactory or not. If the prosecution fails to satisfactorily explain the delay, and there is possibility of embellishment in the prosecution version on account of such delay, the delay would be fatal to the prosecution. However, if the delay is explained to the satisfaction of the court, the delay cannot be by itself be a ground for disbelieving and discarding the entire prosecution case. Next case, the Honorable Apex Court in Dilawar Singh versus State of Delhi, reported in 2007, 12 SCC 641, has held that in a criminal trial, one of the cardinal principles for the delay in lodging the report. Delay sometimes affords opportunity to the complainant to make deliberation upon the complaint and to make embellishment or even make fabrication. Delay defeats the chance of the unsoiled and untarnished version of the case to be presented before the court at the earliest instance. That is why, if there is delay in either coming before the police or before the courts always view the allegations with suspicion and look for satisfactory explanation. If no such satisfaction is formed, the delay is treated as fatal to the prosecution case. Next heading, delay to the magistrate court. No proper explanation, fatal to the prosecution case. The case is State of Rajasthan versus Shiv Singh, AIR 2003 SC 1783. Similar view was taken earlier in Avadesh versus State of MP, AIR 1988 SC 1158. And in State of Rajasthan versus Teja Singh, 2001 SCC Criminal 439. Next, nature of FIR. General diary containing a noting of a report regarding cognizable offence cannot be treated as FIR. Telephonic information to investigating officer. Such information not in the nature of FIR. In the case of Animireddy Venkatramana versus Public Prosecutor, High Court of Andhra Pradesh, 2008 5 SCC 368. Next heading, inquest report. Scope and object. The inquest report is merely to ascertain whether a person has died under suspicious circumstances or unnatural death, and if so, What is the apparent cause of death? Details of the attack of the deceased are not necessary to be mentioned. Refer the case State of UP versus Abdul, AR 1997, SC 2512. The scope and object of inquest report has been elaborately discussed recently in the case of Radha Mohan Singh versus State of UP 2006, that is 2 SCC 450 as follows. Inquest report is limited in scope and is confined to ascertainment of apparent cause of death. It is concerned with discovering whether in a given case the death was accidental, suicidal, homicidal, or caused by an animal, and in what manner and by what weapon or instrument the injuries on the body appear to have been inflicted. Details of overt acts need not be recorded in the inquest report. Question regarding details as to how the deceased was assaulted, or who assaulted him, or under what circumstances he was assaulted, or who were the witnesses of the assault is foreign to the ambit and scope of the proceedings under Section 174. No requirement in law to mention details of FIR, names of the accused or names of the eyewitnesses or gist of their statements in an inquest report, nor is the said report required to be signed by any of the eyewitnesses. The purpose and object of the inquest report under Section 172 of CRPC has been stated as follows. Section 174 read with 178 CRPC says, inquest report is prepared by the investigating officer to find out prima facie the nature of injuries and the possible weapons used in causing those injuries, as also possible cause of death. Non-disclosure of a name of assailants by eyewitnesses. Merely on this ground, eyewitnesses cannot be disbelieved. Refer to the case Suresh Rai versus State of Bihar, AR 2000, SC 2207. Next case is in state represented by Inspector of Police Tamil Nadu versus Rajendran, reported in 2008, 8 Supreme Court 188. It was held by the Honorable Apex Court that, as rightly submitted, the inquest report need not contain the names of all the witnesses. Next heading. Evidentiary value of statements recorded under sections 161 and 164 of CRPC. Evidentiary value. Section 161 CRPC. Statement recorded under 161 CRPC shall not be used for any purpose except to contradict a witness in the manner prescribed in the proviso to the section 162 clause 1. Further, FIR is not a substantial piece of evidence. Refer case Baldev Singh versus State of Punjab 1990, that is 4 SCC 8692, that is equal to AIR 1991 SC 31. In Rajendra Singh versus State of UP 2007, 7 SCC 378, the Honorable Apex Court has held that a statement under Section 161 CRPC is not a substantive piece of evidence in view of the proviso to Section 162 Clause 1 CRPC. Said statement can be used only for the limited purpose of contradicting the maker thereof in the manner laid down in the said proviso. Therefore, the High Court committed a manifest error of law in relying upon wholly inadmissible evidence in recording a finding that respondent 2 could not have been present at the scene of commission of the crime. Section 164 CRPC statement. It can be used for corroboration or contradiction. In the case Sunil Kumar and others versus State of MP reported in EIR 1997 SC 940, the Honorable Apex Court has held that this conclusion of ours, however, does not in any way affect the merits of the prosecution case, for we find that immediately after PW1 was taken to the hospital, his statement was recorded as a dying declaration, which, consequent upon survival, is to be treated only as a statement recorded under Section 164 CRPC and can be used for corroboration or contradiction. Next heading, confrontation of a statement. Section 161 and 162 of CRPC. The witness not confronted with the statement, the court cannot subsequently use the statement even for drawing any adverse impression against the witness. This is said in case of Dandu Lakshmi Reddy versus State of AP, Andhra Pradesh, AIR 1999 SC 3255. Next heading, signing of the statement. Section 161, 162. Statement of the witness. If thumb impression or signature obtained, such statements are unreliable. Gurnam Kaur versus Bakshish Singh in EIR 1981 SC 631. Section 161. Signing of a statement. It merely puts the court on caution and may necessitate in-depth scrutiny of the evidence. But the evidence on this account cannot be rejected outright. This is said in State of UP versus M.K. Anthony, AIR 1985, SC 48. Next heading, confession. What is a confession? A confession must either be an express acknowledgement of the guilt of offence charged, certain and complete in itself, or it must admit substantially all the facts which constitute the offence. In Sahib Singh versus State of Haryana, that is AIR 1997 SC 3247, Honorable Apex Court has held thus. Section 24 provides, though in the negative form, that the confession can be treated as relevant against the person making the confession, unless it appears to the court that it is rendered irrelevant on account of any of the factors, namely threat, inducement, promises mentioned therein, whereas whether the confession attracts the frown of Section 24 has to be considered from the point of view of the confession of the accused as to how the inducement, threat or promise from a person in authority would operate in his mind. Refer to the case Sadbir Singh versus State of Punjab, 1977, 2 SCC 263. Confession has to be affirmatively proved to be free and voluntary. See Hem Rah Devilal versus State of Ajmer, AR 1954, SC 462. Before a conviction can be based on confession, it has to be shown that it was truthful and without the negativity of threat, inducement or promises. Section 25, which provides that a confession made to a police officer shall not be proved against the person accused of an offence, places complete ban on making of such confession by that person, whether he is in custody or not. Section 26 lays down that confession made by a person while he is in custody of a police officer shall not be proved against him, unless it is made in the immediate presence of a magistrate. Section 27 provides that when any fact is discovered in consequence of information received from a person accused of any offence who is in custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates to the fact thereby discovered, may be proved. Section 27 is thus in the form of a proviso to the Section 24, 25 and 26. Section 164, 281, 463 of the Code of Criminal Procedure are the other provisions dealing with confession and the manner in which it is to be recorded. General corroboration. In the case Madi Ganga versus State of Orissa, AR 1981 SC 1165, the Honorable Apex Court has held that it is now well settled that in order to sustain a conviction on the basis of a confessional statement, it is sufficient that the general trend of confession is substantiated by some evidence which would tally with the contents of the confession. General corroboration is sufficient. This is said in the case of Subramanya Gaundan versus State of Madras, AR 1958, SC 66. Next heading, incriminating fact without establishing the guilt. Admission. Incriminating fact without establishing the guilt of the maker is not a confession. This is said in case of Kanda Padayachi versus State of Tamil Nadu, AR 1972, SC 66. Next heading, inculpatory and exculpatory portions of a confession. Confession, appreciation of, acceptance of. Inculpatory portion while ignoring the improbable exculpatory portion. Conviction on the basis of confession. Affirmed by Nishi Kant Jha versus State of Bihar, AR 1969, SC 422, in which case the Honorable Apex Court has held that the exculpatory part of the appellant's statement was not only inherently improbable but was contradicted by the other evidence, and also it was wholly unacceptable. The other incriminating circumstances considered along with the appellant's statement pointed conclusively to his having committed the murder. The court could reject the exculpatory portion of the statement and accept inculpatory portion. In the case Devku Bhika versus State of Gujarat, 1995, AR SC 2171, the Honorable Supreme Court has held that it is settled law that the confession of the accused has to be taken as a whole and the exculpatory part cannot be thrown aside. Next heading, co-accused. Confession, co-accused. Confession of co-accused can be taken into consideration, but it is not substantive piece of evidence. Refer to the case Ramchandra versus State of UP, AR 1957 SC 381. Next, confession of co-accused cannot be treated as a substantive evidence. This is said by Supreme Court in case Bishnu Prasad Sinha versus State of Assam 2007 11 SCC 467, in which the Honorable Apex Court has held that the expression "the court may take into consideration such confession" is significant. It signifies that such confession by the maker as against the co-accused himself should be treated as a piece of corroborative evidence. In the absence of any substantive evidence, no judgment of conviction can be recorded. Only on the basis of a confession of a co-accused, be it extrajudicial confession or a judicial confession, and least of all on the basis of retracted confession. Co-accused and corroboration. Confession, corroboration, co-accused, joint trial of more than one accused. The confession is not irrelevant against the co-accused, but it is a matter of practice that it is not ordinarily acted upon without corroboration. It is in the case in Ram Prakash versus State of Punjab, AR 1959, SC 1. Extrajudicial confession. Confession may be judicial and extrajudicial. If confession recorded by magistrate, it is a judicial confession, and if made to any other person, it is said to be extrajudicial confession. Corroboration. Heading: Confession, extrajudicial, corroboration, necessity of, conviction on the basis of confession without insisting on corroboration, permissibility. It is said in the case of Meghar Singh versus State of Punjab, AR 1975 SC 1320. The Honorable Court in this decision has held as follows: the evidence furnished by the extrajudicial confession made by the accused to witnesses cannot be termed to be a tainted evidence, and if corroboration is required, it is only by way of abundant caution. If the court believes the witnesses before whom the confession is made, and it is satisfied that the confession was voluntary, then in such a case, conviction can be founded on such evidence alone, as was done in the case of Rao Shiv Bahadur Singh versus State of UP, AR 1954 SC 322, where their lordships of Supreme Court rested the conviction of the accused on the extrajudicial confession made by him before two independent witnesses, namely Gadkan and Penulkar. Extrajudicial confession needs corroboration and satisfaction of the procedure related thereto, as said in State of Tamil Nadu versus Manmadhraj 2009 1 Supreme 455. Next heading: Weak piece of evidence. Extrajudicial confession. It is a weak piece of evidence. Reliance cannot be placed unless it is plausible and inspires confidence, as said in case of State of Punjab versus Bhajan Singh, AIR 1975 SC 258. Extrajudicial confession. It may or may not be a weak evidence. Each case should be examined on its own facts and circumstances, as said in case Shivakumar versus State 2006 1 SCC 714. Probative value. Extrajudicial confession, probative value. Such confession cannot be presumed in law to be a weak type of evidence. It depends on the facts and circumstances of each case, as said in Narayan Singh and others versus State of MP, AR 1985 SC 1678. In Gura Singh versus State of Rajasthan 2001 2 SCC 205. It was held by the Honorable Apex Court that extrajudicial confession, if true and voluntary, it can be relied upon by the court to convict the accused to the commission of the crime alleged. Despite inherent weaknesses of extrajudicial confession as an item of evidence, it cannot be ignored when shown that such confession was made before a person who has no reason to state falsely and to whom it is made in the circumstances which tend to support the statement that the evidence in the form of extrajudicial confession made by the accused to witnesses cannot be always termed as a tainted evidence. Corroboration of such evidence is required only by way of abundant caution. If the court believes the witness before whom the confession is made and is satisfied that the confession was true and voluntarily made, then the conviction can be founded on such evidence alone. It is not open to court to trying the criminal case to start with a presumption that extrajudicial confession is always a weak type of evidence. It would depend on the nature of the circumstances, the time when the confession is made, and the credibility of the witnesses who speak for such confession. Next heading: Accused not acquainted with the witness. Extrajudicial confession: accused not acquainted with the witness, witness not having a status in society, no reason shown as to why accused went to the house of witness to confess their crime, confession cannot be believed. Refer the case Sandeep versus State of Haryana, AR 2001 SC 1103. Reposed faith: the prosecution has to show how the accused reposed confidence in a particular person to give extrajudicial confession. Refer case Jaspal Singh versus State of Punjab 1997, SCC Criminal 358. Extrajudicial confession, Section 24, murder, alleged to have been made before two prosecution witnesses. One of them was known to be brother of the deceased. He was neither a sarpanch nor a ward member. Therefore, there was no reason for the accused to repose faith in him to seek his protection. Similarly, other prosecution witness admitted that he was not even acquainted with the accused. Thus said, evidence can be said to be unnatural and unbelievable. Refer the case State of Rajasthan versus Kashiram, 2006 AIR SCW 5768. Next heading: confession to an unknown person. Confession: it was wholly unlikely that the accused would make extrajudicial confession to a person whom they never knew. Refer case Deepak Chandrakant Patil versus State of Maharashtra, 2006 10 SC 151. In the case Jaswant Gir versus State of Punjab, 2005 12 SCC 438. It was held that the witness to whom confession is said to have been made not taken the accused to the police station immediately, and nor reason for the accused to confess the witness with whom he had no intimate relation. The relevant portion is as follows. There is no earthly reason why he should go to PW9 and confide to him as to what he had done. According to PW9, the appellant wanted to surrender himself to the police, but there is no explanation from PW9 as to why he did not take him to the police station. He merely stated that the appellant did not turn up thereafter. The circumstances in which PW9 went to the police station and got his statement recorded by the police on 14/11/97 are also not forthcoming. Ultimately, the Honorable Apex Court has held that the conviction cannot be based on this doubtful testimony. Next heading: confession to an inimical person. Confession: it is improbable, as rightly held by the High Court, that the accused would repose confidence in a person who is inimically disposed towards him and confess his guilt. In the case State of Rajasthan versus Rajaram, 2003 SCC Criminal 1965. Next heading: scope and applicability of extrajudicial confession. Honorable Apex Court in Chattar Singh versus State of Haryana, reported 2008 8 Supreme 178, has held that confessions may be divided into two classes: judicial, extrajudicial. Judicial confessions are those which are made before a magistrate or a court in the course of judicial proceedings. Extrajudicial confessions are those which are made by the party elsewhere than before a magistrate or a court. Extrajudicial confessions are generally those that are made by a party to or before a private individual, which includes even a judicial officer in his private capacity. As to the extrajudicial confessions, two questions arise. One, were they made voluntarily? Two, and are they true? An extrajudicial confession, if voluntarily and true and made in a fit state of mind, can be relied upon by the court. The confession will have to be proved like any other fact. The value of the evidence as to the confession, like any other evidence, depends upon the veracity of the witness as to whom it has been made. The value of evidence as to the confession depends on the reliability of the witness who gives the evidence. It is not open to any court to start with a presumption that extrajudicial confession is a weak type of evidence. It would depend on the nature of the circumstances, the time when the confession was made, and the credibility of the witnesses who speak to such a confession. Such a confession can be relied upon and conviction can be founded thereon if the evidence about the confession comes from the mouth of witnesses who appear to be unbiased, not even remotely inimical to the accused, and in respect of whom nothing is brought out which may tend to indicate that he may have a motive of attributing an unmindful statement to the accused. The words spoken by the witnesses are clear, unambiguous, and unmistakably convey that the accused is the perpetrator of the crime, and nothing is omitted by the witness which may militate against it. After subjecting the evidence of the witness to a rigorous test on touchstone of credibility, the extrajudicial confession can be accepted and can be the basis of a conviction if it passes the rest of credibility. Section 27. Section 27. Information received and documents recovered. Scope and requirement to attract. Section 27. Case Antar Singh versus State of Rajasthan, AIR 2004, SC 2865 is one of the landmark decisions in the respect of Section 27 recovery statement. Relevant portions of the judgment are hereunder. The scope and ambit of Section 27 of the Evidence Act were illuminatingly stated in Palkuri Kotaya versus Emperor, AIR 1947, PC 67, in the following words, which have become local classicus. It is fallacious to treat the fact discovered within the section as equivalent to the object produced. The fact discovered embraces the place from which the object is produced and the knowledge of the accused as to this, and the information given must relate distinctly to the fact. Information as to the past user or past history of the object produced is not related to its discovery in the setting in which it is discovered. Information supplied by a person in custody that I shall produce the concealed knife from the roof of my house does not lead to discovery of knife. Knives were discovered many years ago. It leads to the discovery of the fact that a knife is concealed in the house of the informant to his knowledge, and if the knife is proved to have been used in the commission of the offence, the fact discovered is very relevant. But if to the statement the words be added with which stabbed A, these words are inadmissible, since they do not relate to discovery of the knife in the house of the informant. Next, the aforesaid position was again highlighted in Prabhu versus State of Uttar Pradesh, AIR 1963, SC 1113. Although the interpretation and scope of Section 27 has been subject of several authoritative pronouncements, its application is in concrete cases, and the background events proved therein is not always free from difficulty. It will therefore be worthwhile at the outset to have short and swift glance at Section 27 and be reminded of its requirement. The section says, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered may be proved. The expression provided that, together with the phrase whether it amounts to a confession or not, show that the section is in the nature of an exception to the preceding provisions, particularly sections 25 and 26. It is not necessary in this case to consider if this section qualifies to any extent. Section 24 also. It will be seen that the first condition necessary for bringing this section into operation is the discovery of a fact, albeit a relevant fact, in consequence of the information received from the person accused of an offence. The second in such that the discovery of such fact must be deposed to. The third is that at the time of the receipt of information, the accused must be in police custody. The last but the most important condition is that only so much of information as relates distinctly to the fact thereby discovered is inadmissible. The rest of the information has to be excluded. The word distinctly means directly, indubitably, strictly, unmistakably. The word has been advisably used to limit and define the scope of the provable information. The phrase distinctly relates to the facts thereby discovered and is the linchpin of the provision. This phrase refers to the part of the information supplied by the accused, which is the direct and immediate cause of the discovery. The reason behind this partial lifting of the ban against confessions and statements made to the police is that if a fact is actually discovered in consequence of the information given by the accused, it affords some guarantee of the truth of the part, and that part only of the information which was the clear, immediate and proximate cause of the discovery. No such guarantee or assurance attaches to the rest of the statement, which may be indirectly or remotely related to the fact discovered. See the case Muhammad Inayatullah versus State of Maharashtra, AR 1976, SC 483. At one time, it was held that the expression fact discovered in the section is restricted to a physical or a material fact which can be perceived by the senses, and it does not include a mental fact. Now it is fairly settled that the expression fact discovered includes not only the physical object produced, but also the place from which it is produced, and the knowledge of the accused as to this, as noted in the case Pulukuri Kotaya case and Uday Bhan versus State of Uttar Pradesh, AR 1962, SC 1116. The various requirements of the section can be summed up as follows. 1. The fact which evidence is sought to be given must be relevant to the issue. It must be borne in mind that the provision has nothing to do with the question of relevancy. The relevancy of the fact discovered must be established according to the prescriptions relating to relevancy of other evidence connecting it with the crime in order to make the fact discovered admissible. Next, the fact must have been discovered. Third, the discovery must have been in consequence of some information received from the accused and not by the accused's own act. The person giving the information must be the accused of any offence. He must be in the custody of a police officer. The discovery of a fact in consequence of information received from an accused in custody must be deposed to. Thereupon, only that portion of the information which relates distinctly or strictly to the fact discovered can be proved. The rest remains inadmissible. When Section 27 is not tenable. Section 27, disclosure, statement by accused, robbery and murder, confessional statement by one of the accused mentioning that I am wearing that part which I washed after commission of the offence. Disclosure statement by another accused persons mentioning that I can recover the looted property. Objection to bracketed words plea that the statements hit by Section 24 and 26 of Evidence Act, Section 162 of CRPC, not tenable, more so when consequent upon disclosure statements, articles mentioned therein were actually recovered at the instance of the accused from the place where such articles have been hidden by them. Words objected to do not implicate accused with commission of crime, but refer only to the nature of property hidden by them. Recovery of stolen property. Disclosure statements by the accused proved by testimony of the natural witness, a brother of deceased present during investigation, when accused have made such statements. Fact that no independent witnesses were associated with recoveries. Not sufficient to create doubt in prosecution version. Refer to case Sanjay vs. State, NCT of Delhi, AIR 2001, SC 979. Next heading, recovery of incriminating articles. Section 27, recovery of incriminating articles from place which is open and accessible to others. Evidence under Section 27 would not be vitiated on that ground. There is nothing in Section 27 of the Evidence Act which renders the statement of the accused inadmissible if recovery of the articles are made from any place which is open or accessible to others. It is a fallacious notion. When recovery of any incriminating article was made from a place which is open or accessible to others, it would vitiate the evidence under Section 27 of the Evidence Act. Any object can be concealed in places which are open to accessible to others. For example, if the article is buried on the main roadside, or if it is concealed beneath dry leaves lying in public places or kept hidden in a public office, the article would remain out of the visibility of others in normal circumstances until such article is disinterred. Its hidden state would remain unhampered. The person who hid it alone knows where it is until they discloses the fact to any other person. Hence, the crucial question is not whether the place was accessible to others or not, but whether it was ordinarily visible to others. If it is not, then it is immaterial that the concealed place is accessible to general public or others. Next heading, Dying Declaration. The Honorable Apex Court has held in several cases that there is no bar for basing conviction solely on the dying declaration, but the same should be tested about voluntariness and truthfulness. Honorable Apex Court in P. Mani vs. State of Tamil Nadu, reported 2006 3 SCC 161, has held Section 32 of the Evidence Act 1872, dying declaration must be wholly reliable. In case of suspicion, court should seek corroboration. If evidence shows that the statement of deceased is not wholly true, it can be treated only as a piece of evidence, but conviction cannot be based solely upon it. It is further held in the very same decision that, indisputably, conviction can be recorded on the basis of dying declaration alone, but therefore the same must be wholly reliable. In a case where suspicion can be raised as regards the correctness of the dying declaration, the court, before convicting an accused on the basis thereof, would look for some corroborative evidence. Suspicion, it is trite, is no substitute for proof. If evidence brought on record suggests that such dying declaration does not reveal the entire truth, it may be considered only as a piece of evidence, in which event conviction may not be considered only as a piece of evidence, on which event conviction may not be rested only on the basis thereof. The question as to whether a dying declaration is of impeccable character would depend upon several factors. Physical, mental condition of the deceased is one of them. A leading landmark decision rendered by a 5-judge bench of the Honorable Apex Court in respect of the dying declaration is Lakshman v. State of Maharashtra, 2002 SCC Criminal 1491, in which the Honorable Apex Court has held as follows. The situation in which a man is on the deathbed is so solemn and serene is the reason for law to accept the veracity of his statement. It is for this reason the requirements of oath and cross-examination are dispensed with. Since the accused has no power of cross-examination, the courts insist that the dying declaration should be of such a nature as to inspire full confidence of the court in its truthfulness and correctness. The court, however, has always been on the guard to see that the statement of the deceased was not as a result of either tutoring or prompting or a product of imagination. The court also must further decide that the deceased was in a fit state of mind and had the opportunity to observe and identify the assailant. Normally, therefore, the court, in order to satisfy whether the deceased was in a fit mental condition to make the dying declaration, looks up to the medical opinion. But where the eyewitnesses state that the deceased was in a fit and conscious state to make the declaration, the medical opinion will not prevail. Nor can it be said that since there is no certification of a doctor as to the fitness of the mind of the declarant, dying declaration is not acceptable. A dying declaration can be oral or in writing, and any adequate method of communication, whether by words or by signs or otherwise, will suffice provided the indication is positive and definite. There is no requirement of law that a dying declaration must necessarily be made to a magistrate, and when such a statement is recorded by a magistrate, there is no specified statutory form for such recording. Consequently, what evidentiary value or weight has to be attached to such a statement necessarily depends on the facts and circumstances of each particular case. What is essentially required is that the person who records a dying declaration must be satisfied that the deceased was in a fit state of mind. Whether it is proved by the testimony of the magistrate that the declarant was fit to make the statement, even without examination by a doctor, the declaration can be acted upon provided the court ultimately holds same to be voluntary and truthful. A certification by the doctor is essentially a rule of caution, and therefore the voluntary and truthful nature of the declaration can be established even otherwise. It is indeed a hyper-technical view that the certification of the doctor was to the effect that the patient is conscious and that there was no certification that the patient was in a fit state of mind, especially when the magistrate categorically stated in his evidence, indicating the questions he had put to the patient and from the answers elicited was satisfied that the patient was in a fit state of mind. Whereafter, he recorded the dying declaration. In a recent decision in Amol Singh v. State of MP, 2002, 5 SCC 468, Honorable Apex Court has held as follows. Dying declaration, Section 27 Evidence, Section 32(1) Evidence Act, evidentiary value, multiple dying declarations, inconsistencies, discrepancies in the last dying declaration making it doubtful, held it would not be safe to convict the appellant. Penal Code 1860, Section 302 and 34. Law relating to appreciation of evidence in the form of more than one dying declaration is clear and well settled. Accordingly, it is not the plurality of the dying declarations, but the reliability thereof that adds weight to the prosecution case. If a dying declaration is found to be voluntary, reliable, and made in a fit mental condition, it can be relied upon without any corroboration. The statement should be consistent throughout. If there are more than one dying declaration, they should be consistent. However, if some inconsistencies are noticed between one dying declaration and the other, the court has to examine the nature of the inconsistencies. In such a situation, the court has to examine the same in the light of the various surrounding facts and circumstances. On facts, it would be unsafe to convict the appellant. The discrepancies make the last declaration doubtful. The nature of the inconsistencies is such that they are certainly material. The High Court had itself observed that the dying declaration, Exhibit P11, scribed by the Executive Magistrate PW9 at about 04:35 hours in the same night, was not in conformity with the FIR, and the earlier dying declaration, Exhibit P3, scribed by ASI B PW8, insofar as the different motives have been described. This is not only variation, there are several other discrepancies, even as regards the manner in which she is supposed to have sprinkled with kerosene and thereafter set fire on her. Section 32, Dying Declaration. Recorded in a translated version. Reliability. Declaration made by deceased in Telugu, translated by duty doctor in Tamil, recorded by magistrate in Tamil. Statement so recorded was read over and explained by the doctor to the deceased. Deceased admitted it to be correct. As regards translation, none was cross-examined. No material to show that it was a result of tutoring. Declaration corroborated by evidence of the sister-in-law of deceased is trustworthy and credible. Ravi Kumar alias Kutti Ravi versus State of Tamil Nadu, 2006 AIR SCW 1037. Section 32, Dying Declaration. Contradiction with accidental register. Declaration stating that the accused put a deceased on fire. Case of suicide, however recorded in accident register. Doctor who made the entry, however, explained entry was so made on presumption since the case of injuries was not informed to him at that time. Evidence of doctor clear and unambiguous. Defense case of suicide cannot be accepted on face of two dying declarations recorded by magistrate and police constable and their clear evidence. Ravi Kumar alias Kutti Ravi, State of Tamil Nadu, 2006 AIR SCW 1037. Section 32, Dying Declaration. Deceased wife not keeping good relation with accused husband, was laboring under belief that husband was having an affair. Deceased was suffering from depression, had made an earlier attempt for suicide. All prosecution witnesses stating that the deceased bolted doors of the room from inside. Witnesses along with accused had forced open room and doused fire. Accused himself had taken her to hospital. Circumstances brought on record clearly point out that what might have been stated in a dying declaration may not be correct. Conviction based only on dying declaration is not proper, as said in the case of P. Mani versus State of Tamil Nadu, 2006 AIR SCW 1053. Next, Section 32, Dying Declaration. Deceased was assaulted by accused by sword, axe, etc. Presence or non-presence of eyewitness or non-mentioning of the name of said eyewitness in dying declaration has no connection with ascertainment of veracity and the creditworthiness of dying declaration, thus disbelieving dying declaration of deceased recorded by doctor on ground that the deceased did not mention presence of eyewitness in dying declaration, not proper. Case is Hiralal Yadav versus State of MP, 2006 AIR SCW 3425. Section 32, Dying Declaration. Recording of only because a dying declaration was not recorded by a magistrate. Same by itself may not be a ground to disbelieve entire prosecution case. Case is Balbir Singh versus State of Punjab, 2006 AIR SCW 4950A. Section 32, Dying Declaration. Death by burning. Victim in her dying declaration recorded by doctor stating that her husband had put kerosene oil upon her and upon igniting, locked the door of bathroom from outside. Victim in second dying declaration before investigating officer not only named her husband but also her mother-in-law. Evidence of witnesses stating how deceased received maltreatment at the hands of accused persons for their demand of dowry. Conviction of accused husband under Section 302 is proper. In view of inconsistencies between two dying declarations, benefit of doubt given to the accused mother-in-law. Conviction of both under Section 498A is proper. Case is Balbir Singh versus State of Punjab, 2006 AIR SCW 4950B. Section 32, Dying Declaration. Reliability. Possibility of deceased becoming instantaneously unconscious expressed by doctor conducting postmortem. no ground to disbelieve dying declaration. There is a difference between something possible and something possible or certain, more so when dying declaration was recorded before deceased reached the hospital. Refer case Gangaram Shantaram Salunke versus State of Maharashtra, 2006 AR SCW 5918A. Section 32. Multiple dying declarations reliability. Accused was named in all dying declarations as per who poured the kerosene on the deceased and set him on fire. Dying declarations, though more than one, not contradictory to and inconsistent with each other. Evidence of witnesses corroborating dying declarations. Reliance can be placed on such dying declarations. Refer Vimal versus State of Maharashtra, 2006 AR SCW 5953. Section 32. Dying declaration. Conviction can indisputably be based on a dying declaration, but before it can be acted upon, the same held to have been rendered voluntarily and truthfully. Consistency in the dying declaration is the relevant factor for placing full reliance thereupon. Refer case Mehboob Saab Abba Safi Nadaf versus State of Karnataka, 2007 5 Supreme 713. The Honorable Apex Court in Samadhan Dudka Kohli versus State of Maharashtra, reported 2008 8 Supreme 719, has held that consistency in the dying declaration, therefore, is a very relevant factor. Such a relevant factor cannot be ignored. When a contradictory and inconsistent stand is taken by the deceased herself in different dying declarations, they should not be accepted on their face value. In any event, as a rule of prudence, corroboration must be sought from other evidence brought on record. The Honorable Apex Court in Kalavati, wife of Devaji Dhote versus State of Maharashtra, 2009 1 Supreme 800, has held that in respect of the principles governing dying declaration, which could be summed up as under indicated in Srimati Pani Ben versus State of Gujarat, AIR 1992, SC 1817, there is neither rule of law nor of prudence that dying declaration cannot be acted upon without corroboration. Munnu Raja and another versus State of Madhya Pradesh, 1976, 2 SCR 673. If the court is satisfied that the dying declaration is true and voluntary, it can base conviction on it without corroboration. State of UP versus Ram Sagar Yadav and others, AIR 1985 SC 416, and Ramavati Devi versus State of Bihar, AIR 1983 SC 164. The court has to scrutinize the dying declaration carefully and must ensure that the declaration is not the result of tutoring, prompting, or imagination. The deceased has an opportunity to observe and identify the assailants and was in a fit state to make the declaration. K. Ramchandra Reddy and another versus Public Prosecutor, AR 1976 SC 1994. Where the dying declaration is suspicious, it should not be acted upon without corroborative evidence. Refer Rashid Beg versus State of Madhya Pradesh, 1974 4 SCC 264. Where the deceased was unconscious and could never make any dying declaration, the evidence with regard to it is to be rejected. Refer Kala Singh versus State of MP, AR 1982 SC 1021. A dying declaration which suffers from infirmity cannot form the basis of conviction. Ram Manorath and others versus State of UP, 1981 2 SCC 654. Merely because a dying declaration does contain the details as to the occurrence, it is not to be rejected. State of Maharashtra versus Krishnamurthy Lakshmipati Naidu, AR 1981 SC 617. Equally, merely because it is a brief statement, it is not to be discarded. On the contrary, the shortness of the statement itself guarantees the truth. Refer case Srajdev Ojha versus State of Bihar, AIR 1979 SC 1505. Normally, the court, in order to satisfy whether the deceased was in a fit mental condition to make a dying declaration, looks up to the medical opinion. But where the eyewitness said that the deceased was in a fit and conscious state to make dying declaration, medical opinion cannot prevail. Nanahau Ram versus State of Madhya Pradesh, AIR 1988 SC 912. Where the prosecution version differs from the version as given in the dying declaration, said the declaration cannot be acted upon. Reverse State of UP versus Madan Mohan, AIR 1989 SC 1519. Where there is more than one statement in the nature of dying declaration, one first in the point of time must be referred. Of course, if the plurality of dying declaration could be held to be trustworthy and reliable, it has to be accepted. Mohanlal Gangaram Gehani versus State of Maharashtra, AIR 1982 SC 839. Mohanlal and others versus State of Haryana, 2007, 9 SCC 151. Samadhan Dudka Kohli versus State of Maharashtra 2008 8 Supreme 719. When a contradictory and inconsistent stand is taken by the deceased in different dying declarations, they should not be accepted on their face value. Next, case diary. Next heading is case diary. 172 class 2 case diary. Evidentiary value held. A criminal court can send for the police diaries of a case under trial in such a court and may use such diaries not as evidence of the case but to aid it in such inquiry or trial. Case diary cannot be utilized as evidence to corroborate the statement of prosecution witness. In the instant case, the IO had migrated to Pakistan and had died there, hence he could not be examined by trial court. In such circumstances, trial court looked into the case diary as an additional factor to test the veracity of the witnesses, since the witness confronted with the previous statements that was not prejudicial to the accused in the peculiar facts of the case. Refer case Bachchan Singh vs. State of Bihar 2008 12 SCC 23A. Next heading, common intention and common object. Common intention. Appellants and the co-accused came together and left together, and the appellants restricted the movement of the deceased. As such, liable under section 304 2 read with 34 IPC. Refer Surinder Singh vs. State of Punjab 2006 AIR STW 5454. Common object. Common object. Section 149 IPC. A person can be convicted for his vicarious liability if he is found to be a member of the unlawful assembly sharing the common object, in spite of the fact whether he had actually participated in the commission of the offence. Refer Bhagwan Singh vs. State of MP, AER 2002 SC 1836, that is equal to AER 2002 SC 1621. Common object, section 149 IPC. Overt act need not be proved. Attribution of a definite role of accused is also not necessary. Only requirement is to be found in unlawful assembly. Dani Singh vs. State of Bihar 2005 SCC Criminal 127. Next, common object. Attack with lathis by 6 persons. Only one accused caused fatal blow. Other accused could not be intended to kill the deceased. Section 149 cannot be invoked. Barosi vs. State of MP AIR 2002 SC 3299. The Honorable Apex Court in Vijay vs. State of Karnataka 2008 7 Supreme 578 held as follows. It is equally well settled that where a crowd of assailants who are members of an unlawful assembly proceeds to commit an offence in the pursuance of a common object of unlawful assembly, it is often not possible for witnesses to describe accurately the part played by each one of the assailants. Besides, if a large crowd of persons armed with weapons assaults a victim, it is not necessary that all of them must take part in the actual assault. Even in absence of actual assault, all members of unlawful assembly may be held vicariously liable for the acts of others, provided there was a common object to commit a crime. Appreciation of evidence in such a complex situation is indeed a difficult task, but courts exercising powers in administering criminal justice have to do their best in dealing with such cases. It is expected of them to discharge their duty to sift evidence carefully and to decide which part of it is true and which is not true. Refer the case Masalti vs. State of UP 1964 8 SCR 133. Next heading, common intention. Section 34 to attract section 34 IPC, it has to be established that there was a plan or a meeting of minds of the accused persons to commit the offence, pre-arranged or on the spur of the moment, but before a commission of the actual crime. Refer Killari Malakondaya at Malayadri versus State of Andhra Pradesh 2009 1 Supreme 487. Section 34, common intention, proof of. It is a question of fact which is subjective. It can also be inferred from the facts and circumstances of the case, which include the conduct of the accused, persons acting in concert to commit the offence. Maksudan versus State of UP AR 1983 SC 126. Section 34, common intention, proof of. The common intention to bring out a certain result may develop on the spot itself. Refer Kirpal and others versus State of UP AR 1954 SC 706. Section 34, common intention, scope. Mention of section 34 IPC in judgment is not requirement of law for conviction. Narinder Singh versus State of Punjab AR 2000 SC 2212. Section 34, common intention, sudden fight. The fatal blow caused on the head. The accused who caused fatal injury not established. Accused persons are not liable for common intention to murder. Refer Sri Kishan and others versus State of UP AR 1972 SC 2056. Section 34, Section 34 and 149 common intention, non-framing of a separate charge, accused charged with section 300 read with section 149 IPC, no charge framed under section 34 IPC, common object of the accused persons not proved. However, common intention which was not initially in existence formed during the transaction on the spot is proved. Conviction of the accused for the major offence read with section 34 is permissible. Refer case Madhu Yadav versus State of Bihar, AIR 2002 SC 2137. Section 34 and 300 common intention, overt act, infliction of solitary blow on the neck of the deceased with a sharp-edged weapon, acquittal of the co-accused persons, no evidence on record to prove as to who delivered the fatal blow. The accused in question cannot be convicted for sharing the common intention to murder. Refer Ramchandra Odar versus State of Bihar, AIR 1999 SC 998. Difference between common object with common intention. In Chittamal versus State of Rajasthan, AIR 2003 SC 796, the Honorable Apex Court has held that it is well settled that Section 34 as well as Section 149 deal with liability for constructive criminality, that is, vicarious liability of a person for act of others. Both the sections deal with the combination of persons who become punishable as sharers in an offence. Thus, they have a certain resemblance and may to some extent overlap. But a clear distinction between common intention and common object is that common intention denotes action in concert and necessarily postulates the existence of a pre-arranged plan, implying a prior meeting of minds, while common object does not necessarily require proof of prior meeting of minds or pre-concert. Though there is a substantive difference between the two sections, they also to some extent overlap. It is a question to be determined on the fact of each case whether the charge under section 149 overlaps the ground covered by section 34. Thus, if several persons numbering 5 or more do an act or intend to do it, both section 34 and 149 may apply. If the common object does not involve a common intention, then substitution of 34 or 149 might result in prejudice to the accused and ought not therefore to be permitted. But if it does not involve a common intention, then the substitution of section 34 for section 149 must be held to be a formal matter. Whether such recourse can be had or not must depend on the facts of each case. The non-applicability of section 149 is therefore no bar in convicting the appellants under section 302 read with section 34 IPC if the evidence discloses commission of an offence in furtherance of the common intention of them all. The Apex Court in the case of Rajnath versus State of UP 2009 1 Supreme 370 has stated the difference between the common object is different from a common intention as follows. A plea which was emphasized by appellant relates to the question whether section 149 IPC has any application for fastening the constructive liability which is a sine qua non for its operation. The emphasis is on the common object and not on common intention. Mere presence in an unlawful assembly cannot render a person liable unless there was a common object and he was actuated by that common object, and that object is one of those that set out in section 141. Where common object of an unlawful assembly is not proved, accused persons cannot be convicted with the help of section 149. The crucial question to determine is whether the assembly consisted of 5 or more persons, and whether the said persons entertained one or more of the common objects as specified in section 141. It cannot be laid down as a general proposition of law that unless an overt act is proved against a person who is alleged to be a member of unlawful assembly, it cannot be said that he is a member of an assembly. The only thing required is that he should have understood that the assembly was unlawful and was likely to commit any of the acts which fall within the purview of 141. The word object means the purpose or a design, and in order to make it common, it must be shared by all. In other words, the object should be common to the persons who compose the assembly, that is to say, they should all be aware of it and concur in it. A common object may be formed by express agreement after mutual consultation, but that is by no means necessary. It may be formed at any stage by all or a few members of the assembly, and other members may just join and adopt it. Once formed, it need not continue to be the same. It may be modified or altered or abandoned at any stage. The expression in prosecution of a common object as appearing in section 149 have to be strictly construed as equivalent to in order to attain the common object. It must be immediately connected with the common object by virtue of the nature of the object. There must be community of the object, and the object may exist only up to a particular stage and not thereafter. Members of an unlawful assembly may have community of object up to a certain point, beyond which they may differ in their objects, and the knowledge possessed by each member of what is likely to be committed in prosecution of their common object may vary, not only according to the information at his command, but also according to the extent to which he shares the community of the object. And as a consequence of this, the effect of Section 149 IPC may be different on different members of the same assembly. Common object is different from a common intention, as it does not require prior concert and common meeting of minds before the attack. It is enough if each has the same object in view, and the number is 5 or more, and as they act as an assembly to achieve that object. The common object of an assembly is to be ascertained from the acts and language of the members composing it, and from consideration of all surrounding circumstances. It may be gathered from the course of conduct adopted by the members of the assembly. For determination of the common object of the unlawful assembly, the conduct of each of the members of unlawful assembly before and at the time of attack, and thereafter the motive for the crime, are some of the relevant considerations. What the common object of an unlawful assembly is at a particular stage of incident is essentially a question of fact to be determined, keeping in view the nature of the assembly, arms carried by the members, behavior of the members at or near the scene of the incident. It is not necessary under the law that in all cases of unlawful assembly with an unlawful common object, the same must be translated into action or be successful. Under the explanation to Section 141, an assembly which was not unlawful when it was assembled may subsequently become unlawful. It is not necessary that the intention or the purpose which is necessary to render an assembly an unlawful one comes into existence at the outset. The time of forming an unlawful intent is not material. An assembly which at its commencement or even for some time thereafter is lawful may subsequently become unlawful. In other words, it can develop during the course of incident at the spot co-instanti. Next heading, conspiracy. Number 10. It is well settled that from the very nature a conspiracy must be conceived and hatched in complete secrecy, and it is impossible and very rare to get direct evidence. It is also equally well settled that it is not necessary that each member to conspiracy must know all details of the conspiracy. Honorable Supreme Court in Muhammad Khalid vs. West Bengal 2002 7 SCC 334 has held that for an offence punishable under 120B, the prosecution need not necessarily prove that the perpetrators expressly agreed to do or caused it to be done an illegal act. The agreement may be proved by necessary implication. It further held in the very same decision that offence of conspiracy can be proved by either direct or circumstantial evidence. However, conspiracies are not hatched in the open by their nature, they are secretly planned. Privacy and secrecy are more characteristics of a conspiracy than of a loud discussion in an elevated place open to public view. Direct evidence in a proof of conspiracy is therefore seldom available. It is not always possible to give affirmative evidence about the date of the formation of the criminal conspiracy, about the persons who took part in the formation of the conspiracy, about the object which the objections set before themselves as the object of conspiracy, and about the manner in which the object of conspiracy is to be carried out. All that is necessary a matter of inference. Therefore, the circumstances proved before, during, and after occurrence have to be considered to decide about the complicity of the accused. Where trustworthy evidence establishing all links of circumstantial evidence is available, the confessions of a co-accused as to the conspiracy, even without corroborative evidence, can be taken into consideration. It can in some cases be inferred from the acts and conduct of the parties. The Honorable Apex Court has held in K.R. Purushottaman vs. State of Kerala, AIR 2006 SC 35 as follows. To constitute a conspiracy, meeting of mind of two or more persons for doing an illegal act or an act by illegal means is the first and primary condition. It is not necessary that all the conspirators must know each and every detail of conspiracy. Neither it is necessary that every one of the conspirators take active part in the commission of each and every conspiratorial act. The agreement amongst the conspirators can be inferred by necessary implications. In most of the cases, conspiracies are proved by the circumstantial evidence, as the conspiracy is seldom an open affair. The existence of conspiracy and its objects are usually deducted from the circumstances of the case and the conduct of the accused involved in the conspiracy. Refer case V. Tyagarajan and others vs. State by IG Police, SPG, CBE, ACB, Chennai. Essential ingredients. In Suresh Chandra Bahari versus State of Bihar, AR 1994 SC 2420, Honorable Apex Court has held that Section 120 capital A reveals that a criminal conspiracy envisages an agreement between two or more persons to commit an illegal act or an act which by itself may not be illegal, but the same is done or executed by illegal means. Thus, the essential ingredient of offence of criminal conspiracy is the agreement to commit an offence. In a case where the agreement is for accomplishment of an act which by itself constitutes an offence, then in that event no overt act is necessary to be proved by the prosecution, because in such a fact situation, criminal conspiracy is established by proving such an agreement. In other words, where the conspiracy alleged is with regard to the commission of a serious crime of nature as contemplated in section 120b, read with the proviso to subsection 2 of section 120a of IPC, then in that event mere proof of an agreement between the accused for commission of such a crime alone is enough to bring about a conviction under 120b, and the proof of any overt act by the accused or by any one of them would not be necessary. The provisions in such a situation do not require that each and every person who is party to the conspiracy must do some overt act toward the fulfillment of the object of conspiracy, the essential ingredient being an agreement between the conspirators to commit the crime. And if these requirements and ingredients are established, the act would fall within the trapping of the provisions contained in section 120b, since from its very nature, a conspiracy must be conceived and hatched in complete secrecy, because otherwise the whole purpose may be frustrated. It is the common experience and goes without saying that only in very rare cases one may come across direct evidence of a criminal conspiracy to commit any crime. In most of the cases, it is only the circumstantial evidence which is available, from which inference may give rise to the conclusion of an agreement between two or more persons to commit an offence may be legitimately drawn. Next heading, test identification parade. Reliance on evidence. Identification parade. Identification by witness. It is not safe to place implicit reliance on the evidence of a fleeting glimpse of an accused. It is extremely risky to place implicit reliance on the identification for the first time before the court. Refer State of Maharashtra versus Sukhdev Singh, AR 1992 SC 2100. Identification parade beyond doubt. No ID parade. Accused not known to the witness. Identification accused cannot be believed beyond doubt. Chandrapal versus State of Haryana, AIR 2002 SC 989. D. Gopalakrishnan versus Sadanand Naik, AIR 2004 SC 4965. Similar view. Next heading, identification of more than one accused. Identification parade. Identification of more than one accused in the same parade. Effect, placing of accused husband and wife in the same identification parade held was contrary to the criminal manual issued by High Court. Hence, courts below rightly disbelieved the identification of the accused in their identification parade. State of Goa versus Sanjay Thakran, 2007, 2 SCC, Criminal 162. Next heading, accused unknown to witness. Identification parade. Accused unknown to witness and witness identifying the accused for the first time before the court, and there is no identification parade. No value could be attached to such evidence. Kannan and others versus State of Kerala, 1980 MLJ Criminal 1. Belated identification. Belated identification in court. No identification parade held. Witness cannot be believed. State of Maharashtra versus Sukhdev Singh, AR 1992 SC 2100. Next heading, evidentiary value. Identification parade value. Person required to identify an accused should have had no opportunity of seeing him after commission of the crime before identification. Refer Bodhsen versus State of UP, AIR 1970, SC 1321. Next heading, witness already seen the accused. If the witness already seen the accused after arrest and before identification parade, no value can be attached to such evidence. Refer Bodhsen versus State of UP, AIR SC 1321. Next heading, test identification parade not a decisive factor. Section 9 of the Evidence Act. Test identification parade cannot be the decisive factor for recording conviction. Identification do not constitute substantive evidence. Refer case Mahabir versus State of Delhi, 2008 3 Supreme 111. Next heading, identification of accused or articles. A person can be identified even in darkness from the manner of speech, style of walking, and other peculiar features. Refer case State of MP versus Makhan, 2008 10 SCC 615B. Next heading, expert opinion. A. Doctor's opinion. Doctor's opinion should be about the weapon, though theoretical, cannot be totally wiped out. Refer case Anwarul Haq versus State of UP, 2005, 10 SCC 581. Not binding on court. Honorable Apex Court in Amar Singh Ramji Bhai Barot versus State of Gujarat, 2005, 7 SCC 550 held that Evidence Act, Section 45, opinion of expert, binding nature of, opinion by Forensic Science Laboratory that the substance recovered from the accused was opium, not accepted. Held the opinion was not binding on a court. Medical evidence, Section 45, expert evidence, medical evidence. Conflict between the medical evidence and the ocular evidence about the type of murder weapon used. Conviction on such evidence is not permissible. Refer Mohar Singh versus others and others versus State of Punjab, AIR 1981, SC 1578. Conflict between medical and ocular testimony. Ocular testimony should be preferred. Refer State of Punjab versus Hakam Singh, 2005, 7 SCC 408. Evidentiary value. Section 42. Expert evidence, evidentiary value. The evidence of an expert is not conclusive. S. Gopal Reddy versus State of Andhra Pradesh, AIR 1996, SC 2184. The relevant portion is hereunder. The evidence of an expert is a rather weak type of evidence, and the courts do not generally consider it as an offering conclusive proof, and therefore safe to rely upon the same without seeing independent and reliable corroboration. In Magan Bihari Lal versus State of Punjab, AR 1977 SC 1091, while dealing with the evidence of a handwriting expert, this court opined, "We think it would be extremely hazardous to condemn the appellant merely on the strength of an opinion evidence of an handwriting expert. It is now well settled that an expert opinion must always be received with great caution, and perhaps none so with more caution than the opinion of a handwriting expert. There is profusion of presidential authority which holds that it is unsafe to base a conviction solely on the expert opinion without substantial corroboration. This rule has been universally acted upon and it has almost become a rule of law. It was held by this court in Ramchandra versus State of UP, AR 1957 SC 381, that it is unsafe to treat expert handwriting opinion as sufficient basis for conviction, but it may be relied upon when supported by other items of internal and external evidence. This court again pointed out in Ishwari Prasad Mishra versus Muhammad Isa, AR 1963 SC 1728, that expert evidence of handwriting can never be conclusive because it is after all opinion evidence, and this view was reiterated in Shashi Kumar Banerjee versus Subodh Kumar Banerjee, AR 1964 SC 529, where it was pointed out by this court that expert evidence as to handwriting, being opinion evidence, can rarely, if ever, take the place of substantive evidence, and before acting on such evidence, it would be desirable to consider whether it is corroborated either by clear direct evidence or by circumstantial evidence. This court has again occasion to consider the evidentiary value of expert opinion in regard to handwriting in Fakhruddin versus State of MP, AR 1967 SC 1326, and it uttered a note of caution pointing out that it would be risky to found a conviction solely on the evidence of a handwriting expert, and before acting upon such evidence, the court must always try to see whether it is corroborated by other evidence, direct or circumstantial. Next heading, admissibility. Section 45, expert evidence, admissibility. It must be shown that expert had necessary skill and adequate knowledge before relying upon such evidence. Refer State of Himachal Pradesh versus Jailal, 1999, AIR SC 3318. Next heading, ballistic expert. Section 45, expert evidence, ballistic expert, appreciation of opinion. Expert failing to categorically say whether two injuries could have been caused by the single shot. The direct evidence of eyewitness could not be doubted on account of such oscillating opinion. Refer Anwaruddin and others versus Shakur and others, AR 1990 SC 1242. Section 45, expert evidence, ballistic expert. Inconsistency with ocular evidence. No explanation for inconsistency discredits the entire case. Refer Ram Narayan versus State of Punjab, AR 1975 1727. Dog tracking. Section 45, expert evidence, dog tracking, evidentiary value. Scientific knowledge of dog tracking, even if admissible, is not of much weight in evidence. Refer Abdul Razak Murtuza Daftadar versus State of Maharashtra, AR 1970 SC 283. Footprint experts. Section 45, expert evidence. Footprint evidence, identification by footprint. Identification of footprint is not a fully developed science. Refer Muhammad Aman versus State of Rajasthan, AR 1997 SC 2960. Handwriting expert. Section 45, expert evidence, handwriting expert, evidentiary value of opinion. The opinion is not conclusive. Conviction solely on such opinion is normally not sufficient. Refer the State of Gujarat versus Vinaya Chandra Lal Pathi, AR 1967, SC 778. Next, next heading, tape recorder evidence. Tape recorder evidence, evidence admissible guidelines. Refer Yusuf Ali Ismail Nagri versus State of Maharashtra, AR 1968, SC 147. R.K. Malkani versus State of Maharashtra, AR 1973, SC 157. Mahabir Prasad Verma versus Dr. Surinder Kaur, 1982 to SCS 258. In Mahabir case, Honorable Apex Court has held as follows. Tape recorded conversation can only be relied upon as corroborative evidence of conversation deposed by any of the parties to the conversation, and in the absence of evidence of any such conversation, the tape recorded conversation is indeed no proper evidence and cannot be relied upon. Brain mapping test. Scientific test, brain mapping test. Lineage Dalmia versus State 2006, 1 MLJ, Criminal 411. Next heading, DNA test. Evidence, Section 112 and 4 of IEA 1872. Conclusiveness of presumption under Section 112 held cannot be rebutted by DNA test. DNA test value of, refer Banarsi Das versus Tiku Datta 2005, 4 SCC 449. Compulsion and parties, DNA test. A party to a proceeding cannot be compelled against his or her wish to undergo any such DNA test. The court on its own could not have imposed a condition without any condition whatsoever. Refer Amarjit Kaur versus Harbhajan Singh 2003, 10 SCC 228. Next heading, circumstantial evidence. Section 3, medical evidence. Alleged variance with ocular evidence. Eyewitnesses' account found to be credible and trustworthy. Medical evidence pointing to alternative possibilities is not to be accepted as conclusive. 2008 AR SCW 5578. Prosecution case solely based on circumstantial evidence. Heading, evidence. Appreciation of prosecution can solely based on circumstantial evidence. Principles of appreciation of circumstances from which the conclusion of guilt can be drawn. Refer Sarbir Singh versus State of Punjab 1993. Supplementary 3 SCC 41. It was held. It is said that men lie but circumstances do not. Under the circumstances prevailing in the society today, it is not true in many cases. Sometimes the circumstances which are sought to be proved against the accused for purpose of establishing the charge are planted by the elements hostile to the accused, who find out witnesses to fill up the gaps. That men may lie but circumstances do not. Under circumstances prevailing in the society today, it is not true in many cases. Sometimes the circumstances which are sought to be proved against the accused for purpose of establishing the charge are planted by the elements hostile to the accused, who find out witnesses to fill up the gaps in the chain of circumstances. In countries having sophisticated modes of investigation, every trace left behind by the culprit can be followed and pursued immediately. Unfortunately, it is not available in many parts of this country. That's why the courts have insisted: 1. Circumstances from which the conclusion of guilt is to be drawn should be in the first instance be fully established. 2. All facts so established should be consistent only with the hypothesis of guilt of the accused and should be such as to exclude every hypothesis but the one sought to be proved. 3. Circumstances should be of a conclusive nature. 4. The chain of evidence should not have any reasonable ground for a conclusion consistent with the innocence of the accused. In Padala Veera Reddy versus State of AP 1989, Supplementary 2, Supreme 706, Honorable Apex Court has laid down the principle that when a case rests upon circumstantial evidence, such evidence must satisfy the following tests. 1. Circumstances from which an inference of guilt is sought to be drawn must be cogently and firmly established. 2. Those circumstances should be of definite tendency, unerringly pointing towards guilt of the accused. 3. Circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability the crime was committed by the accused and none else. And 4. The circumstantial evidence in order to sustain conviction must be complete and incapable of explanation of any other hypothesis than that of the guilt of the accused, and such evidence should not only be consistent with the guilt of the accused but should be inconsistent with his innocence. The Honorable Apex Court in Chattar Singh versus State of Haryana reported 2008 8 Supreme 178 held that there is no doubt that the conviction can be based solely on circumstantial evidence, but it should be tested by such touchstone of law relating to circumstantial evidence laid down by this court as far back as 1952. In Hanumant Govind Nargunkar versus State of Madhya Pradesh, AR 1952, SC 343, wherein it was observed that it is well to remember that in cases where the evidence is of circumstantial nature, the circumstances from which the conclusion of a guilt is to be drawn should be in the first instance be fully established, and all the facts so established should be consistent only with the hypothesis of the guilt of the accused. Again, the circumstances should be of a conclusive nature and tendency and should be such as to exclude every hypothesis but the one proposed to be proved. In other words, there must be a chain of evidence so far complete as not to leave any reasonable ground for a conclusion consistent with the innocence of the accused, and it must be such as to show that within all human probability the act must have been done by the accused. Honorable Apex Court reiterated the above principles in Baldev Singh versus State of Haryana, reported 2008, 8 Supreme 544. Appreciation of not to cull out one circumstances from the rest. That's the heading. Circumstantial evidence appreciation of. Court should not cull out one circumstance from the rest to give a different meaning to it. Refer case Gade Lakshmi Mangaraju versus Ramesh versus Andhra Pradesh, AIR 2001, SC 2677. Hypothesis of the guilt. Circumstantial evidence appreciation of. Circumstances must be consistent with the hypothesis of the guilt of the accused and totally inconsistent with his innocence. Circumstances from which the conclusion of guilt is to be drawn should be fully proved, and circumstances must be conclusive in nature to connect the accused with crime. Court should not get swayed by emotional considerations. Refer Balwinder Singh vs. State of Punjab, AR 1996, SC 607. Conditions for reliance. Conditions for reliance. Test to be satisfied before convicting an accused on the basis of circumstantial evidence. The circumstantial evidence in order to sustain conviction must be complete and incapable of explanation of any other hypothesis than that of the guilt of the accused. The circumstantial evidence should not only be consistent with the guilt of the accused, but should be inconsistent with his innocence. Refer Gambhir vs. State of Maharashtra, AR 1982, SC 1157. Missing link to connect the accused. Non-explanation of the accused as to what happened on fateful night. Section 313 statement. Chain of circumstances completed. Witness may lie. Circumstances will not. In the case of Joseph vs. State of Kerala, 2000, SCC Criminal 926. Circumstantial evidence. Evidence must be complete and incapable of explanation on any other hypothesis except that of the guilt of the credibility. Case State of Orissa vs. Brahmananda, AIR 1976, SC 2488. Eyewitness not informing about the incident till the third day to anyone. Unnatural conduct, unsafe to rely upon their testimony. Case Harbanslal vs. State of Punjab, 1996, SCC Criminal 312. Eyewitness not disclosing the fact to anybody that he being an eyewitness till the next day, conduct unnatural, not safe to sustain conviction. Refer Joseph vs. State of Kerala, 2003, SCC Criminal 38356. Section 3. Conduct of witness. Mere consistent version of the witness not sufficient to show the truthfulness, and if the court comes to the conclusion that the conduct of the witness is such that it renders the case of the prosecution doubtful or incredible, or that their presence at the place of occurrence as eyewitness is suspect, the court may reject their evidence. Refer Badam Singh vs. State of MP, AER 2004, SC 26. Stating conduct of the accused. Conduct of the accused would be relevant under Section 8 of the Evidence Act if his immediate reaction in the illegal overture of the complainant or his action in inserting unwanted something in his pocket were revealed in the form of acts accompanied then and there and are immediately thereafter by words or gestures reliably established. Refer Moha Singh versus State of Delhi Administration, AIR 1976, SC 449. Appreciation of evidence. An inferential conclusion without any evidence to show participation of the accused cannot be sustained. Refer Suresh Hakia versus State of Haryana, 2008, 3 Supreme 182. Next heading, non-explanation of injuries. Accused injuries, non-explanation of injuries, fatal, genesis, origin and suppressed. Lakshmi Singh versus State of Bihar, AIR 1976, SC 2263. In this decision, it was held by the Honorable Apex Court that when in a murder case, the non-explanation of the injuries sustained by the accused at about the time of occurrence or in the course of altercation is a very important circumstance from which the court can draw the following inferences. And the prosecution has suppressed the genesis and origin of the occurrence and has thus not presented the true version. That the witnesses who have denied the presence of injuries on the person of the accused are lying on a most material point and therefore their evidence is unreliable. That in case there is a defense version which explains the injuries on the person of the accused, it is rendered probable so as to throw doubt on the prosecution case. Omission on the part of the prosecution to explain the injuries on the person of the accused assumes much greater importance where the evidence consists of interested or inimical witnesses or where the defense gives a version which competes in probability with that of the prosecution one. Section 3. Injuries to accused. Non-explanation effect murder case. Witnesses vividly described the incident and part played by each accused. All witnesses were injured and their presence at the spot cannot be doubted. Injuries suffered by accused were simple. Non-explanation thereof would not dislodge prosecution case which is established by evidence of creditworthy witnesses. Refer Mohinder Singh vs. State of Punjab 2006 AIR SCW 1610. Murder, non-explanation of injuries, minor and superficial injuries would not affect prosecution case. Refer Shah Jahan vs. State of Kerala 2007 AIR SCW 2123. Next heading witnesses. Sole eyewitness, not of sterling quality, not safe to base conviction. Section 3. Sole eyewitness to murder, evidence of credibility. Failure to prove motive is not fatal if evidence of witnesses appears to be truthful and convincing. Thumb mark of eyewitness. Mother of deceased was taken 5 times on blank sheet of paper and after first information report was lodged, she was never questioned by police. Absence of bloodstains on the clothes of the eyewitness or a mother or younger brother of deceased suggests that they had not witnessed the occurrence. Absence of bloodstains explained by saying that she only touched the body of the deceased to find out whether she was alive. Unnatural. Improvement made by the mother in an attempt to project the presence of younger brother from the very beginning of occurrence, which is not true. Testimony of solitary eyewitness. Mother is not of sterling quality. Not safe is to base a conviction solely on testimony of that witness. Benefit of doubt given to the accused. Refer Binnappa Chandappa Hosmani vs. State of Karnataka 2006 AIR SCW 5043. Next heading solitary witness conviction on basis of. It is well settled that the court can place reliance on a solitary witness provided the same inspires confidence. If such evidence of a single witness is clear, cogent and consistent, there is no other infirmity, there is absolutely no impediment in placing reliance on such evidence and the court need not seek for corroboration. In Sunil Kumar vs. State of Government NCT Delhi 2003 11 SEC 367, the Honorable Apex Court has held that Vadivelu Devar case AIR 1957 SC 614 was referred to with approval in the case of Jagdish Prasad vs. State of MP AIR 1994 SC 1251. The court held that as a general rule, the court can and may act on the testimony of a single witness, provided he is wholly reliable. There is no legal impediment in convicting a person on sole testimony of a single witness. That is the logic of Section 134 Indian Evidence Act 1872, in short, Evidence Act. But if there are doubts about the testimony of the courts will insist on corroboration, it is for the court to act upon the testimony of witnesses. It is not the number, the quantity, but the quality that is material. The time-honored principle is that evidence has to be weighed and not counted. On this principle stand the edifice of Section 134 of Evidence Act. The test is whether the evidence has a ring of truth, is cogent, credible, trustworthy, or otherwise. Criminal trial witness, solitary witness, related testimony of held can be basis of conviction even in related to the deceased. Absence of corroboration held on facts inconsequential. Refer case State of Rajasthan vs. Om Prakash 2007 12 SEC 381. Next case criminal trial witnesses, solitary witness, testimony of conviction on the basis of permissible, where testimony of sole eyewitness PW2 was not shaken although he was cross-examined at length and the same was corroborated by evidence of PW1 who did not support the prosecution version in toto. Held conviction based on the sole testimony of PW2 was not liable to be interfered with. Penal Code 1860, Section 302, Testimony of Sole Witness, Evidence Act 1872, Section 134. Refer case Kunju vs. State of Tamil Nadu 2008 2 SEC 151. The Honorable Apex Court in Munna at the rate of Puran Yadav alias Puran Yadav vs. State of Madhya Pradesh reported in 2008 8 Supreme 51 has held as follows. Learned Counsel appearing on behalf of the state relied on decision reported in Kunju alias Balachandran versus State of Tamil Nadu 2008 2 SCC 151, which deals with the subject of the appreciation of a single eyewitness. This court, following the oftly quoted decision in Vadivelu Devar versus State of Madras AIR 1957 SC 614, and accepting that decision, came to the conclusion that this court can and may convict relying on the testimony of a single witness provided he is wholly reliable, and that there was no legal impediment in convicting a person on the sole testimony of a single witness. Honorable Apex Court in Jarnail Singh versus State of Punjab reported in 2009 1 Supreme 224 has held that it is no doubt true that conviction could be based on sole testimony of a solitary eyewitness, but in order to be the basis of conviction, his presence at the place of occurrence has to be natural, and his testimony should be strong and reliable and free from any blemish. In Chuhar Singh versus State of Haryana 1976 1 SCC 879, this court held that what is important is not how many witnesses have been examined, but what is the nature and quality of evidence on which it relies. Evidence of a single witness may sustain a sentence of death sentence, whereas a host of vulnerable witnesses may fail to support a single charge of hurt. Since the case must stand or fall by the evidence of a single witness, it is necessary to examine that evidence critically. Next heading. Interested and partisan witnesses. The evidence of interested witnesses cannot be thrown out, and the only requirement for the court is to consider their evidence with great care and caution, and if such evidence does not satisfy the test of credibility, then the court can disbelieve the same. Refer Mallanna versus State of Karnataka, reported 2007 8 SCC 523. In yet another decision in Kulesh Mondal versus State of West Bengal, reported 2007 8 SCC 578, the Heritage Apex Court has held that we may also observe that the ground that the witnesses being close relatives and consequently being partisan witnesses should not be relied upon has no substance. This theory was repelled by this court as early as in Dalip Singh versus State of Punjab AIR 1953, Supreme Court 364, in which the surprise was expressed over the impression which prevailed in the minds of the members of the bar that relatives were not independent witnesses. Speaking through Vivian Bose, judge, it was observed, AIR page 366, para 25. We are unable to agree with the learned judges of the High Court that the testimony of the two eyewitnesses required corroboration if the foundation for such observation is based on the fact that the witnesses are women, and that the fact that the fate of 7 men hangs in their testimony. We know of no such rule. If it is grounded on the reason that they are closely related to the deceased, we are unable to concur. This is a fallacy common to many criminal cases, and one which another bench of this court endeavoured to dispel in Rameshwar versus State of Rajasthan AIR 1952 SC 54. We find, however, that it unfortunately still persists, if not in the judgment of the courts, at any rate in the arguments of the counsels. Again, in Masalti versus State of UP AIR 1965 SC 202, this court observed, AIR page 209 to 10 para 14. But it would, we think, be unreasonable to contend that evidence given by witnesses should be discarded only on the ground that it is evidence of partisan or interested witnesses. The mechanical rejection of such evidence on the sole ground that it is partisan would invariably lead to failure of justice. No hard and fast rule can be laid down as to how much evidence should be appreciated. Judicial approach has to be cautious in dealing with such evidence, but the plea that such evidence should be rejected because it is partisan cannot be accepted as correct. Evidence of the injured and other eyewitnesses went to be labelled as interested witness. The Apex Court in the case of Ramakant Verma versus State of UP and others 2008 8 Supreme 848 has held as follows. The witnesses could not have stated the scenario with surgical precision in State of AP versus Konda Gopaludu 2005 13 SCC 116. It was inter alia observed as follows. We have been taken through the evidence of PWs 1, 2 and 3, before whom extrajudicial confession has been made by the accused. The testimony of PWs 1, 2 and 3 is consistent. The learned counsel for the respondent pointed out that in the evidence of PWs 1 and 2, there is contradiction that the accused did not state before them that he came seeking protection from them. In our view, this discrepancy cannot be termed as a contradiction, which would be fatal to the prosecution case. Every discrepancy in the statement of a witness cannot be treated as fatal to the prosecution case. A discrepancy which is not fatal to the prosecution case does not create any infirmity. The incident had taken place on 24/1/92 and PW2 was examined on 22/1/96 after almost 4 years. Human memories are apt to blur with the passage of time. After a lapse of almost 4 years, it cannot be expected that a witness can depose with mathematical precision. Next, in B.K. Chennappa versus State of Karnataka, 2006, 12 SCC 57, it was inter alia observed as follows. We have independently scrutinized the evidence of the material witnesses in the teeth of the rival contentions of the parties. On reappraisal and scrutiny of the evidence of the injured witnesses, Shekharappa, PW2, B.G. Shiva Murthaya, PW3, and B.G. Prakashaya, PW4. They have fully established the case of the prosecution against A2, A3, A17, A19, and A20, although there was certain discrepancies in their testimony and in comparison to the version of prosecution witnesses, the eyewitnesses, in regard to the weapons of the offense individually used by A1, A3, A17, A19, and A20 for inflicting injury on the person of each of the injured witnesses as also on the person of the deceased. The discrepancies, as pointed out by the learned counsel for the appellants, are minor and insignificant. The occurrence took place on 5/7/95 and the witnesses were examined in the court after about a gap of about 4 years. The evidence on record further shows that the injured witnesses had been subjected to lengthy and searching cross-examination. In such type of cross-examination, some improvements, contradictions, and omissions are bound to occur in their evidence, which cannot be treated as very serious, vital, and significant so as to disbelieve and discard the substantive portion of the prosecution case. The evidence of the injured witnesses and other eyewitnesses have been rightly reappreciated and accepted by the High Court, and we find no cogent and sound reason to differ from the well-reasoned judgment upholding the order of the trial court. There is, therefore, no merit in the argument of the learned counsel for the appellants that the evidence of the injured witnesses and other eyewitnesses should be labelled as evidence of the interested witnesses. On the other hand, we find that the evidence of all the eyewitnesses, including injured persons, is quite natural, convincing, and trustworthy. There is no material on record from which an inference can be drawn that the material witnesses have implicated the appellants. Kambappa A2, Halainka A3, BP Manjunatha A17, BK Parameshwarappa A19, and BK Shivarajappa A20 in a false case. Next heading, hostile witness. Section 3, hostile witness. Evidence cannot be rejected in toto merely because prosecution chose to treat him as hostile and cross-examine him, but can be accepted to the extent the version is found to be dependable on a careful scrutiny thereof. Refer 2006 AIR SCW 421B. Section 3, proof of guilt. Fact that prosecution witnesses held hostile may be act of dishonesty on their part, but not sufficient to prove guilt of accused. Refer Vikramjit Singh alias Vicky versus State of Punjab 2006 AIR SCW 6197F. The well-settled principle of law laid down by the Honorable Apex Court is that the evidence of a hostile witness cannot be rejected in toto, and any portion either in favor of the defense or in favor of the prosecution can very well be relied upon by the court to arriving at a just decision. In Satpal versus Delhi Administration reported AIR 1976 SC 294, the Honorable Apex Court has held as follows. Even in a criminal prosecution where a witness is cross-examined and contradicted with the leave of the court by the party calling him, his evidence cannot, as a matter of law, be treated as washed off the record altogether. It is for the judge of fact to consider in each case whether, as a result of such cross-examination and contradiction, the witness stands thoroughly discredited or can still be believed in regard to the part of his testimony. If the judge finds that in the process the credit of the witness has not been completely shaken, he may, after reading and considering the evidence of the witness as a whole, with due caution and care, accept in the light of other evidence on record that part of his testimony to which he finds to be creditworthy and act upon it. If in a given case the whole of the testimony of the witness is impugned, and in the process the witness stands squarely and totally discredited, the judge should, as a matter of prudence, discard his evidence in toto. Inimical witness. Heading. Section 3. Inimical witness. Reliability. Enmity not delaying. Prosecution case itself alleging that accused person's crime to beat complainant. Evidence of witnesses who are injured cannot be rejected on the ground of enmity. Kallu alias Masti versus State of Madhya Pradesh. 2006 AIR SCW 177E. Next, interested witness. Section 3. Interested witness. Evidence otherwise reliable. Witness has also received injury in the incident. His evidence cannot be discarded merely on the ground that he is an interested person. Refer 2006 AR SW 1302. Section 3. Interested witness. Evidence of credibility of relationship is not a factor to affect credibility of a person. Foundation has to be laid if the plea of false implication is made. Refer 2006 AIR SW 3680A. Section 3. Interested witness. Evidence of credibility. Murder case. Nothing elicited in cross-examination of eyewitnesses. Their evidence corroborated by complaint and medical evidence and weapon seized in on disclosures made by the accused cannot be rejected even though they were closely related to deceased and inimically disposed toward the accused. 2006 AER SW 4143. Next heading, non-examination of independent witness. Section 3. Non-examination of independent witness when fatal. What is necessary for proving prosecution case is not the quantity but quality of evidence. Offense is committed in a village over a land dispute. Independent witnesses may not come forward. However, some of the witnesses examined by the prosecution are independent. Their evidence is more or less consistent. Nothing has been pointed out to discredit their testimony. Testimonies of said witnesses cannot be rejected on the ground that all witnesses are not examined. 2006 AIR SW 4186A.